Welcome back to the deep dive. Today, we are stripping away the physical act of crime to look at something much more subtle, but honestly equally dangerous. We're talking about words.
Just words.
Exactly. Specifically, at what point does a conversation, just words floating in the air, crystallize into a punishable felony? I mean, we think of crime as an act, right? Pulling a trigger, stealing a car.
Right. Smashing a window.
But the law says that simply asking someone else to do those things can be a crime in itself.
It creates this, fascinating legal boundary. We're exploring the doctrine of criminal solicitation. And it forces us to ask some pretty uncomfortable questions, like, does the person listening even have to agree to the crime? What if they're secretly working for the police?
And this is the part that just gets me. What if the message you send asking for a crime to be committed is never even delivered? I mean, does the crime just exist in a vacuum?
That's the part that usually trips people up.
Yeah, it feels like a philosophical riddle. To navigate this, we're going to unpack the seminal New York case of People v. Lubow. It's a 1971 case that, it feels like it was ripped right out of a Scorsese movie script.
Oh, absolutely.
You've got diamond dealers, a massive bankruptcy fraud scheme, fake gambling trips to Vegas, and a wiretap.
It really is a perfect case study. It has all the drama of a heist movie, but, it all turns on statutory interpretation.
Mm-hmm.
And New York's approach to solicitation is particularly aggressive. It doesn't wait for the crime to happen. It strikes at the very formation of the idea.
So let's get into it. I've been looking at the statute here, New York Penal Law Section 100.05. It just seems incredibly broad. It basically says, if I intend for you to commit a crime and I just ask you to do it, I'm on the hook. Is it really that simple?
It is, and that simplicity is a little deceptive. The court in Lubow breaks this down into two very distinct components or elements. You have the mens rea, the mental state, and the actus reus, the physical act. For the mental state, you need specific intent. You can't just be like joking around or venting. You have to specifically intend for another person to engage in conduct that is a crime.
Okay, so if I say, oh, I wish someone would punch my boss, that's not solicitation because I'm just venting. But if I say, I want you to go punch my boss, that's closer.
Exactly. But then you need the second part, the actus reus. The statute says the accused must solicit, request, command, importune, or otherwise attempt to cause that person to engage in the conduct. That language is really key. It covers a lot of ground.
Importune, that's a word you don't hear every day.
No, it sounds very persistent.
Right. But here's the thing I want to clarify immediately because it just seems so counterintuitive. Does the other person, the one I'm asking, actually have to do it? If I ask you to rob a bank and you just look at me like I'm crazy and walk away, have I still committed solicitation?
You have. And that is the critical distinction between solicitation and, say, conspiracy. In solicitation, nothing needs to be done in furtherance of the communication. The communication is the crime. The moment you ask with that specific intent, you've crossed the line.
So the crime is entirely in my behavior, not yours.
Correct. You're guilty based on your output, not the reaction of the listener.
That brings us to the edge of the cliff, though. The statute has this phrase, otherwise attempts to cause.
Mm-hmm.
That sounds incredibly broad. I want to test that with a hypothetical before we get to the diamond dealers. Let's say I want my business rival eliminated. I sit down, I write this detailed letter to a known hitman offering him money, I put a stamp on it, walk to the mailbox, drop it in.
Okay, so you've initiated the process.
Right. But then, let's say the mailman is clumsy, he drops the letter in a puddle, the ink runs, he just throws it away. It's never delivered. The hitman never knows I even wrote it. Am I guilty?
This is one of those scenarios that feels completely unfair, but under the statute in Lubow and under the Model Penal Code, the answer is yes, you are guilty.
Wow. Even though no one heard me, that feels like a thought crime.
It's close, but it's not quite a thought crime because you took a physical step. You mailed the letter. That clause, or otherwise attempts to cause, is written to embrace an undelivered letter. The court in Lubow notes that New York law aligns with the Model Penal Code on this. It's immaterial if the actor fails to communicate, as long as the conduct was designed to affect that communication.
But why? Why punish someone for a letter that no one even read?
Because of what it says about you. The law punishes your effort to set the wheels of a crime in motion. The fact that you failed because of a puddle doesn't make you any less malicious. It just makes you unlucky. And the law doesn't want to reward your bad luck.
That is terrifying and fascinating. Okay, let's see how this played out in the real world. Let's analyze People v. Lubow. First, what are the legally dispositive facts?
Okay, so the facts here, they're pretty wild, actually. The context is the rough-and-tumble diamond trade in the late 60s. We have a complainant, Max Silverman, and the defendants, Samuel Lubow and Oscar Gissinger,
All in the jewelry business.
all in the jewelry business, which runs on credit and reputation. The whole thing started with a debt. Lubow owed Silverman $30,000 for diamonds.
And 30,000 in 1967 is what, like $250,000 today?
It's a massive amount. So in October 67, Silverman meets with them and demands his money. He says, look, this debt is killing me. It's forcing me into bankruptcy. Now, a normal person might say, okay, I'll pay you back or give me more time. But Lubow, he proposed what he called a big bankruptcy.
A big bankruptcy. That sounds ominous. And Kissinger was on board with this.
He was, chimed in and agreed it was a good idea. And this wasn't just some vague idea. They laid out a whole bust-out operation. It's startlingly sophisticated.
Like a recipe for fraud.
A perfect recipe.
Stage 1.
Purchase diamonds on credit. Use your existing credit to get as much inventory as possible.
Okay, so you have the diamonds. Stage 2.
Stage 2 is where it gets weird. You sell those diamonds for less than they cost.
Why would you do that? You're just losing money.
Because you're not trying to make a profit. You're trying to generate cash flow. It's called pyramiding. You take that quick cash and you pay off your suppliers immediately. This makes Silverman's credit rating shoot through the roof.
I see. You're grooming the creditors. So you build up this sterling reputation. Then what?
Stage 3. The trap snaps shut. Once the credit rating is maxed out, you make one final massive purchase of inventory from everyone.
And then stage 4, declare bankruptcy.
Exactly.
But wait, the creditors are going to ask, where's the money? Where are the diamonds? You can't just say, oops.
And that's where the scheme gets cinematic. They needed a cover story. The plan was to claim all the cash was lost gambling, specifically in Puerto Rico and Las Vegas.
The classic, I lost it all at the tables.
Right. But to make the lie believable, they told Silverman to use his credit cards in those places, buy dinner, check into hotels, to create a paper trail proving he was there. They figured they'd each walk away with $250,000.
$250,000 each in 1967. Wow. So obviously, since we're reading a court case, the plan went wrong. What happened?
Silverman got cold feet. Instead of joining in, he went straight to the district attorney. The DA's office then equipped Silverman with a concealed tape recorder for his next meeting.
The wire.
The wire. And that tape captured the whole conversation, substantiating the proposal.
And what was the core legal issue?
The issue was whether the evidence was sufficient to prove the defendants importuned Silverman to engage in grand larceny, even though they knew he was never actually going to do it because he was working with the cops.
The it takes two to tango defense. So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule is New York Penal Law, Section 100.05. It has two elements. First, the accused must have the specific intent that another person engage in conduct constituting a crime. And second, the accused must solicit, request, command, importune, or otherwise attempt to cause that person to engage in the conduct.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, intent?
Right, intent. The sub-issue was, were they serious or just talking? The court looked at the sheer complexity of the plan. The pyramiding of credit, selling goods for pennies on the dollar.
The Las Vegas trip.
The fake gambling cover story, exactly. The court basically said you don't accidentally plant a fake paper trail. And the promise of $250,000 each showed this was a serious proposal. So the specific intent to commit grand larceny was established.
Understood. Now, what about the second element, solicitation importuning? This gets back to Silverman being an informant.
It does. And the court did not buy their argument. They applied the statute strictly. They found the defendants did importune Silverman. And the key legal distinction here, the big takeaway, is that the crime is complete upon communication. It is immaterial that the object of the solicitation is never consummated.
So the fact that Silverman was wearing a wire is totally irrelevant to their guilt.
Completely irrelevant to the definition of the crime, yes. The fact that the solicitee Silverman was working with the police doesn't relieve the solicitor of liability. They did their part. That's all the statute requires. The element was met.
And after analyzing all the elements, what was the court's final conclusion?
Judgment affirmed. The proof met the actual terms of the statute. The court said the law is a valid exercise of legislative power to prevent crime before it even starts.
Now, I want to pivot to something the court mentioned. Even though they upheld the conviction, the judge seemed a little uneasy. He talked about potential difficulties with this statute. What was the court worried about?
This is the critical policy discussion. The problem is that the New York statute does not require corroboration. Judge Bergen, writing for the court, highlighted the risk. In a lot of these cases, it's just one person's word against another's.
The classic he said, she said.
Exactly. And you can imagine how dangerous that is. The court mentioned crimes like solicitation of sexual offenses or perjury. There's a huge risk of misinterpreting innuendos, or worse, facing a completely false accusation from a single witness.
It's a weapon for blackmail. Do what I say or I'll tell the cops you solicited a bribe. Does every state do it this way? The source material mentioned California.
No, and the court points to California as a contrast. They reference Justice Trainer's opinions in cases like Benson and Burt. California's law is much more protective. It requires two witnesses or one witness plus corroborating circumstances.
So California builds in a safety net.
Right. They want to prevent that exact blackmail scenario.
But wait a minute, New York doesn't have that safety net. So why was the court okay with the conviction in Lubow? Why didn't they say this is too risky?
Because of the technology. In this specific case, that risk was mitigated because Silverman was wearing a tape recorder. That tape provided independent support for his testimony. So while the statute didn't technically require corroboration, the existence of the tape removed the danger of relying on just one person's word.
So the wiretap saved the prosecution. It feels like the court is sending a message to prosecutors. We'll let you use this law, but you better be careful.
Precisely. It's about the sufficiency of the evidence. The court is saying, we won't strike down the law, but we are definitely watching how you use it.
This has been a huge amount of information. To synthesize this, if a listener is looking at a messy situation, how do they know if they're looking at criminal solicitation? Can you give us a checklist?
Absolutely. We can boil this down to a 5-step diagnostic checklist based on everything we've talked about.
Okay, walk us through it. Step 1.
Step 1, identify the mental state. Does the actor have the specific intent that the other person commit a crime? Look for purposeful solicitation, not just idle chatter. The details of the plan are your best clue.
Got it. Step 2.
Step 2, identify the act. Did the actor actually communicate a request, a command, an importunity? Basically, did they ask?
Okay. Step 3. This is the tricky one.
Step 3, check for failed communication. If the message was undelivered, our letter in the puddle applied the otherwise attempts to cause rule. Remember, under New York law and the MPC, this is still solicitation.
Step 4.
Step 4, disregard the solicitee's response. This is so important. It does not matter if the listener says no or is an undercover agent. If the solicitor asks, the crime is complete. Don't get distracted by what the listener does or doesn't do.
And what's the last step?
Step 5, check jurisdiction for corroboration. This is that policy piece. Remember that under the MPC and New York law, no corroboration is required. But in other places, like California, you must look for 2 witnesses or corroborating circumstances.
That framework really clarifies it. It all comes down to the idea that solicitation is a crime of asking, not a crime of doing.
That is the ultimate goal of the statute. It protects society from being exposed to inducements to commit crime. The law decides that the person who tries to persuade others to break the law is a danger, regardless of their success rate.
The person who tries to persuade, that really sticks with me. That wraps up our deep dive into People v. Lubow. Review that checklist, keep the bust-out scheme in mind, and I guess, remember, be careful what you asked for.
Indeed. In the eyes of the law, the question itself can be the crime.